You are Robert Eagland?
Yes.
And give me just a second. Mr. Eagland is charged with aggravated assault on a family member with a deadly weapon, and Mr. Lewis has filed a motion asking that his bond be reduced. The bond is currently, let's see,
It was 150.
what is it set at now? Do y'all know?
I think 150.
150. And it looks like there was we were set for trial,
Right.
and there was the state requested a continuance, and so Mr. Lewis has filed this motion to reduce bond. Ms. Malfino, what is the state's position?
Yes, Judge, the state did file a formal written motion to bring it before the court. I certainly understand that Mr. Eagland via Mr. Lewis certainly entitled to ask for bond reduction based upon that announcement. Where I am is that the complainant in this case, if the court will recall, it was originally handled in CDC. She was unable to be located. So although the often stated in the indictment looks old, he has not been in custody for that length of time. So I'd like you to take that into consideration. She has recently had a stroke. She is still in recovery for that medical condition. I spoke with her on the phone. She's always been very attentive in reaching out to us. It's difficult. Her mobility is severely limited. Her speech is still limited based on that stroke. And for that reason, I would ask the court to consider allowing for continuance off of that December 8th docket, and so that we could know in advance so she doesn't have to leave her rehab facility. And I've discussed that with Mr. Lewis, who's always been very courteous about it. I understand the necessity for him to ask for a bond.
Sure. Mr. Lewis?
And Judge, that parcel is cut. That involves, of course, the length of time that he did sit in custody while he was in this case was pending over in CDC. I think it was a very lengthy time, almost 3 years. Is what he was in custody for before that case was dismissed, because they could not locate her. Shortly after that, of course, he was refiled. He's been in custody all of this time. We were ready to go to trial because the stroke happened right before the last trial set. And I think, we discussed it at that point, which I was gonna, and this was the first update we've gotten that she's still dealing with the rehab and everything.
Okay. So,
And typically, Judge would know not to ask more than once. It's just a very severe medical condition.
sure,
And it's a
yeah.
very
No, I'm
serious
going to grant the
aggravated
motion for continuance, but in turn, I think I'm required under
Yes.
17151 to do something with regard to the bond. So I want to get some specific information from you, Mr. Eagland, so that I know conditions to place on that bond. Where will you live if you make bond?
My mother,
What is her name?
Marvel,
Marva
Eagland,
Eagland, okay. And what is that address?
3705 East Lucas Drive.
'Cause that's here in Beaumont,
Yes.
okay. As far as you know, Ms. Malfino, obviously there will be some restrictions and no contacts. Was there any issue that you know of when Mr. Eagland was out from the time that case was dismissed until the case was refiled with any type of contact or threats or communication with the complaining witness?
Not that I'm personally aware of, Judge. I certainly would be happy to talk to Mr. Laird about it. I know that the complainant at the present time is very concerned for her safety, just based upon the aggravated nature of the offense, and I don't feel like it's necessary to show the court the pictures of that, but I think you would probably
I'm looking at the
agree.
probable cause, so it's an allegation of being stabbed multiple times?
Her throat was slit, yeah.
Okay.
Again, I certainly understand the bond requirement and would ask that in the event he does postpone, that he have to wear a GPS at all times so that we can monitor his whereabouts. I know the complainant's whereabouts. I would like him not to know that, and also for him to remain in Jefferson County, specifically in Belmont, if the court would allow. He also has a prior felony conviction.
I'm sorry?
He also has a prior felony conviction.
Okay. All right, so here's what I'm going to do, based on the, my granting that motion for continuance. I am going to grant the motion under 17.151 to reduce the bond as well in Mr. Eagland's case. I'm going to reduce your bond to $25,000 in your case. There are going to be several conditions that are extremely important. The first is that you will be required to wear a GPS monitoring device at all times. You will be on house arrest except for employment with my permission. So if you have opportunities to get employment, you need to get with Mr. Lewis. He'll let me know. All it takes is an email and I can approve or not, things like that. Also, obviously you can come to court and you can visit with your attorney, medical doctors, things like that. But other than that, you are to be on house arrest at 3705 East Lucas here in Beaumont. You're not to leave Beaumont. You are going to be restricted to live and work in Beaumont, Texas. Do you understand those restrictions?
I can speak now. I'm trying to change venue, motion to change venue because this case is prejudiced and it's been dismissed and it's been brought up 20 days later while I was out there helping my dying mother. I didn't do it the first time.
Okay, so here's the thing. You got a lawyer, motion to change. All right, you're not
I
going.
wrote the state bar about it and I'm.
Your motion to
trying
change,
get some-
all right, listen,
I'm
your
just
motion,
trying to get something
listen,
done.
don't talk over me, okay? Because I can change my mind real quick on what I just did.
I'm not even trying to bond out, ma'am. I'm trying to get out of the county with this case so that this case can get.
That's denied. Your case is going to be here in this court with me, okay?
Yeah, I understand.
So
But I don't need the bond though.
then I'm going to withdraw everything that I just said. I'm going to deny the motion for bond reduction. And so what we'll do is just reset the case on the next available trial docket and we'll move forward with trial. Go back with the bailiff. I'll print the first. If you can print the second, please. Just a second. Good morning. Are you Byron DeQueer? Will your client waive the formal reading of the motion in each case?
He will, Your Honor.
Give me just a second.
We can narrow down some of the counts.
I cannot hear you.
We can narrow down some of the counts on the M2LP.
Okay.
There's like 13 counts.
What do you want to go forward on?
We'll go for first 7.
Okay. State's going to proceed on 1 through 7 in each case. Okay. And Mr. DeQueer, in cause number 23, DCCR 1448, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation July 2nd of 2024 for the second-degree felony offense of assault on a peace officer, and that was a 10-year deferred probation. Is that correct? Yeah, it's just correct that you were placed on probation on that day, right? Are they printing? Huh? I feel like yours is closer, but it takes longer to print than mine.
My computer has stopped. And some of that is just take it out and.
Do we need a new print? What do we need to do? Everything? We need a new TV. We need a new printer. We need new computers.
Thank goodness it's Christmas.
We need new tablets.
Just ask Santa.
Unfortunately, Santa is on the 4th floor of the old courthouse, and I missed that opportunity during budget season to ask for all this extra stuff. Okay. Okay, now, in cause number 23, DCCR 1449, I also have a motion to revoke your unadjudicated probation. This one also shows you were placed on probation July 2nd of 2024 for that same offense, assault on a peace officer, second-degree felony, and that was also a deferred probation for 10 years. Is that correct? Each of these cases allege that you violated your probation, and the state has elected to proceed in counts 1 through 7 in each. Count 1 in each case alleges that you provided a urine sample July 14th of 2025 that tested positive for methamphetamines. And is that true or not true?
True.
Count 2 in each case alleges that you provided a urine sample August 12th of 2025 that also tested positive for methamphetamines and amphetamines. Is that true or not true? Count 3 in each case alleges that you provided a urine sample August 25th of 2025 that also tested positive for methamphetamines and amphetamines. Is that true or not true? Count 4 in each case alleges that you tested positive August 26th of 2025 for methamphetamines and amphetamines. Is that true or not true?
True.
Count 5 in each case alleges that you tested positive September 10th of 2025 for amphetamines, methamphetamines, and ecstasy. And is that true or not true?
True.
Count 6 in each case alleges that you tested positive September 16th of 2025 for methamphetamines. Is that true or not true?
True.
And then count 7 in each case alleges that you failed to conduct yourself in a courteous and professional manner at all times when interacting with your probation officer, and that you were argumentative, raised your voice, and became verbally aggressive toward them. Is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 7 freely and voluntarily? And did you plead true to those counts because they're actually true?
True. Yes, ma'am.
I have here on the tablet some documents in each of your cases that have your signature on them that the state has marked as exhibit number 1. Before you signed those documents, did you go over them with Mr. Rojas? And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've reached with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1 in each case.
No objection.
It's admitted. Is there any evidence that Mr. DeQueer is not competent?
No, Your Honor.
All right, sir, in each of your cases, I'm going to find that you entered your pleas of true to counts 1 through 7 freely and voluntarily. Find those counts true. And cause number 23, DCCR 1448, find sufficient evidence to find you guilty, and at this time, find you guilty. Sentence you in accordance with your agreement to a term of 5 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And cause number 23, DCCR 1449, also find counts 1 through 7 true. Find sufficient evidence to find you guilty, and at this time find you guilty of assault on a peace officer. Sentence you in accordance with your agreement to a term of 5 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence also for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm going to hand you, in each of your cases, the trial court certification that shows these were agreements that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, sir. You can go back with the bailiff. Taylon Douglas, Mr. Rojas, it's a sentencing.
No.
Okay, I'm just going to give me just a minute to
Yeah,
do.
no, I was supposed to be in hard guy.
Okay,
Take all that.
okay, thank you. Good morning, are you Brittany Litchfield? Give me just a second to get this printed out. And will your client waive the formal reading of the motion in each case?
Yes, Your Honor.
Ms. Litchfield, in cause number 21-37098, I have a motion to revoke your community supervision shows that you were placed on probation December 12th of 2022 for the state jail felony offense of abandoning a child, and that was a 2-year term in the state jail prison that was probated for 5 years. Is that correct?
Judge will still abandon, I guess it's 6 and 7 on each motion and just proceed on 1 through 5.
In each motion, 1 through 5?
Yes, ma'am.
It's okay. All right, and then in cause number 21-37099, I also have a motion to revoke your community supervision. Shows you were again placed on probation December 12th of 2022 for the offense of abandoning a child, and that was also a 2-year term in state jail prison that was probated for 5 years. Is that also correct? Each of these cases, the state has elected to proceed on counts 1 through 5 in the motions. They each allege in count 1 that you violated your probation by failing to report to the probation department as directed October 15th, October 31st, and November 14th of 2024. And is that true or not true? Count 2 in each case alleges that you failed to work faithfully at suitable employment and provide verification of that. Is that true or not true? Count 3 in each case alleges that you failed to immediately report to the probation officer your current address. Is that true or not true? Count 4 alleges that you failed to provide verification of performing the community service hours that were required. Is that true or not true? And then count 5 alleges that you failed to provide verification of entering and successfully completing the parenting class. And is that true or not true? Did you enter your pleas of true to counts 1 through 5 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts in each case because they're actually true?
Yes, ma'am.
In each of your cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreements that you've reached with the district attorney, that you will be waiving or giving up any right to appeal? State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Ms. Litchfield is not
No,
competent?
Your Honor.
All right, ma'am, in each of your cases, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence in each case to revoke your probation. In cause number 21-37098, revoke your probation and reassess your punishment in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 25-37099, also find sufficient evidence to revoke your probation, and at this time revoke your probation, reassess your punishment in accordance with that agreement to a term of 12 months in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm going to hand you in each case the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. Good luck to you, ma'am, and thank you for being here.